Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. Our guest this week is Peter Torin. Mike Keys and Matt Curtis are here with me as well. Today, Grumpy Cat wins big. You get a blockchain, and you get a blockchain. The wonder of sleeves. Who owns Guantanamo art, and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by CashFly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, Mike Keys, and Matt Curtis. Episode 412, recorded January 26th, 2018. Putting Grumpy Matt on the blockchain. This episode of This Week in Law is brought to you by Grammarly. Download Grammarly, the intelligent writing app, for free by visiting getgrammarly.com/twit. And by Grasshopper. Stay connected and run your business from your mobile phone with Grasshopper. To save $50 on your order, visit trygrasshopper.com/twit. Hi, folks. I'm Denise Howell, and you're joining us for This Week in Law. We're so excited to be here. We're all, I don't know why exactly, but seemingly in great moods today. So we hope you are too, because we've got some wonderful, interesting, fascinating stories to discuss at the intersection of technology and the law. My two wonderful co-hosts are here with me today. Mike Keys is here. Mike is a partner at the Dorsey firm in Seattle. Hi, Mike.
Hi, Denise. I'm always in a great mood.
I know you are. That's one of the things we love most about you. So it's wonderful to see you.
Great to see you, and great to see Matt again, and excited to be here with Peter as well.
And me too. Yes, joining us as our guest today is Peter Torin, who's a definite repeat guest here on This Week in Law. It's great to have you back, Peter.
Thank you. Great to be here.
Peter's a lawyer and the author of Intellectual Property and Computer Crimes. And so we're going to get into some of that material later on in the show. What else have you been up to, Peter, since we last spoke?
Since I last spoke, I finished working on chapters on a book on the Defend Trade Secrets Act, which, as you and your viewers may know, it's the act that was passed by Congress about a year and a half ago, for the first time federalizing the civil trade secret law. Before that, there'd been the Economic Espionage Act, but that only applied for trade secrets in criminal cases. So now we've got a federal trade secret act on the book, and working on areas in protection and helping people protect their trade secrets.
That's great. It's wonderful to see you again.
Thank you.
And as I mentioned, my other co-host is here, and he is Matt Curtis, who's a law student at Notre Dame. Hi, Matt. Great to see you.
Hi. Good to be back again. And unlike Mike, I have my mopey days, so I think it was well noted that Denise said that we were all happy. And we're back here in South Bend, and it's 50 degrees, and all the snow is melting on the south side of the road. So everyone here is chipper and happy, and yeah, so everything's good, and glad to be back on.
Great to see you again. Are you close to where the Super Bowl is going to be? I'm betraying my lack of Midwestern geography right now.
And I'm betraying my lack of football knowledge by not knowing where the Super Bowl is going to be.
Nor Minneapolis.
Minneapolis, Minnesota. Is that anywhere near where you are?
It's like
an hour and a half
plane
ride, right?
It's kind of like traveling to Seattle for you.
Oh God, that's not close at all. Sorry.
No. Yeah, it's a 3-hour train ride, then an hour and a half plane ride.
That's great. So
better stick with your law gig, Denise.
Yeah. I'm going to stick with the tech law, because clearly my Midwestern geography and my football knowledge are both lacking. But I'm going to fess up right here. I don't even know who's in the Super Bowl. We do know who's in the Super Bowl, right? We know at this point.
It's the Patriots and the Eagles, I believe.
There we go.
Win one for Mike.
Mike, you have to hold up the sports end of the show here for us.
I'll try, but I'm not your guy for that. That's for sure.
You're not. No. Okay. So then let's stick to what we know and let's talk about some copyright stories. So we ended last week's show talking about some things that shouldn't be on the blockchain. Perhaps your consent app is something that you might want to think about and ponder before you decide that the various consents that it is collecting need to exist on the blockchain. But I thought it was really interesting when I got a press release from somebody who wanted me to know that the founder of a company called Encore will be speaking at the world's first blockchain fashion conference of all things during Kiev Fashion Week. So I looked a little bit more into Encore, and the reason I think it's really interesting they reached out to me on the fashion front, which obviously has a host of IP issues associated with it, is that Encore, as it is postured, seems to be all about digital works. Your video, your music, anything you would create and then post and then perhaps be disturbed that it was being reused without your permission. That seems to be where Encore is aimed. But with Eric Klein, its founder, speaking at the blockchain fashion conference, apparently they have some other aims in mind as well. So maybe we're back to, does everything need to be on the blockchain? What do you think, Mike?
Yeah, I was really fascinated by this. I was unfamiliar with it until we were preparing for the show today. I think they raise, particularly in their white paper that I took a look at, raise some pretty interesting issues about what's going on. Of course, authenticating creation of IP can be particularly difficult in light of digital environments. So, what they're doing here, as I understand it, is they're using blockchain technology for IP tagging, which will help people establish that they are the creator of a particular digital work that's at issue. So it's a really interesting article. Highly commend it to folks that are interested in this.
Yeah, I think it certainly won't be the only thing like this of its kind. It may not right now be the only thing like this of its kind. It just sort of hit my radar when someone reached out to me about it. But it seems to want to augment and take international what various sovereign nations have laws about. Here in the United States, you might register your copyright with the U.S. Copyright Office and then attempt to enforce it. This seems to perhaps provide you an additional piece of evidence that you would bring in your enforcement action to show, hey, not only did I register my copyright, but, if you're not in the U.S. or if you're in any sort of international realm, maybe this would serve a similar sort of purpose to take the thing that you created and provide it with a date and timestamp and then allow you to go out and enforce your intellectual property rights. What do you think about this, Matt?
Yeah, I don't know how big of a problem it is for creators to identify and to prove that they created something. So I guess if maybe you guys have more experience with that, but if it's not a problem, it's kind of a solution looking for a problem and therefore not super valuable. Where I think it would be valuable or would have been valuable 10 years ago, and this gets back to the Redigi case that we've talked about a couple times, is that if there when you're selling a copy of something, if you could have had a unique identifier for that specific copy, and therefore you could have validated that when the copy was transferred to someone else, it would have been destroyed. So that could have been valuable in terms of saving the first sale doctrine. But the reality is that no one, not that no one owns music anymore, but the trend has gone away where you're streaming music and not owning music. So I think that would have been a great application of blockchain technology. But I don't know that it's a pain point in the market right now of identifying that someone made the work.
Hey, Denise.
Yes.
One thing that I thought about that it may be extremely helpful is with regard to takedown notices of copyrighted. Believe that your work is up on wherever, and sending a takedown notice that I think it would go a long way to improving somebody's ability to enforce takedown notices under the DMCA, and also what third parties may be expected to check on with regard to their copyrighted works, So it's even more than just enforcing it in a court of law.
Yeah, you raise a really good point there, Peter, because when it comes down to practicalities, most copyright disputes these days, especially involving digital works online, don't go to court. They get resolved in the DMCA notice and takedown process. And the companies administering their sites find themselves in that role, unenviable role of having to determine, who in that process wins. You send a notice, you send a counter notice, does the work stay up or down? I think that's an excellent point, Peter, that if you provided not just your notice or your counter notice, but some sort of, look, I registered this, it's on the blockchain, here you go. That would at least give the companies some assurance that their decision making is justified.
What do you think? Can I jump in here?
Yeah.
So I think that's like online dispute resolution seems like a great thing. And so if we could solve disputes online through like a mediated forum of some sort that's helped by technology, that's great. I don't know how blockchain is necessary for that. Even with just a relational or non-relational database, you could have put the image up there and said, this is mine. And you could have used, image recognition to search the internet to find other images that were used improperly. I don't the blockchain technology itself isn't what's doing the work here. It's the online dispute resolution. So I think that that's a great thing to do. I just don't know, I'm kind of a blockchain hater, so that's just my caveat. I just
We're
don't
gathering
think that.
You're getting grumpier than when we started the show.
I know. Yeah. It's just not a panacea. I think it's good for a few things, and it's really good at verification of unique things. But I just don't. I don't know. I don't see how it uniquely solves that problem. I think that what's solving that problem is online dispute resolution.
Right. I get where you're going, but I guess the benefit of having something like this on the blockchain would be that it is verifiable. You can trust it. It's decentralized. It's not something that can be fabricated. Whereas maybe something else could.
Yeah, then it just gets down to the question of how much do you trust a rational database and or non-relational database of the Amazon offers for very cheaply. And I guess I just trust what Amazon and Google are producing in terms of trusting it and not having that's how our world works today. I'm not sure that blockchain's going to provide massively more security than what we have there. And also blockchain's really expensive. The energy consumption that goes along with blockchain is astronomical. So it may be that's in terms of protecting your IP rights. I'm just not sure the cost outweigh the benefits. Anyways, I'll get off my rant.
It's a really good point. I mean, with the rush to blockchain technologies that we're seeing in the market right now, it may well be that international climate treaties may want to start looking into what really needs to be on the blockchain and what does not. What do you think, Mike?
Well, I think Peter does raise an excellent point about how this could help in the DMCA takedown process, because oftentimes, and I've dealt with this issue myself, particularly when you're dealing with big online platforms that you have to deal with, oftentimes you run into a situation where you've got an infringer on the other side, you've got a party that you're representing, and the other side will say, no, I created this. I've dealt with that situation over the years on a lot of occasions. And the client may not have a copyright registration already. Maybe they've already submitted it to the Copyright Office, but that can take 6 months, 8 months, 12 months, and beyond to actually get the certificate of registration. So this could be a nice little stopgap measure. If you would have essentially a digital fingerprint on this particular work showing the date it was created, that could help speed up potential resolution under the notice and counter notice provisions of the DMCA. So I think there is definitely a use for this. And to Matt's point about the expense, maybe it's too expensive right now, but of course, as time wears on, the cost of this will no doubt come down.
Mike, doesn't that the benefit that you're proposing, doesn't that rely on somebody when they create something submitting it to the blockchain? So if they don't create it, aren't you going to have the same problems?
Yeah, of course. I think that's exactly right, Matt. I mean, this is only so good as people use it in kind of the ordinary course. So it will call for widespread adoption before it's ultimately you're going to be very useful, I suppose. But as the cost comes down and it becomes more accessible and more available for folks, it may be something that people readily adopt. Who knows?
Super interesting. Reminds me a little of Creative Commons that way.
Yeah.
Especially with the machine readable license component of Creative Commons. It's effective, but it depends if you're using it or not.
If it was costless to send your copyright into the government, I don't know how much it is right now to send a copyright in, but if it was a costless right now and we trusted them to verify it, like if people put their creations in copyright and send it to the government right away, then the same effect would happen as if you use blockchain, as long as no one's being able to manipulate it, which is, that's the main benefit.
Well, but not really, Matt, because there's a substantial delay anytime you're dealing with the federal government, believe it or not, at least with the Copyright Office. It takes, unless you expedite a copyright application, which can be $1,000 plus per application, but in the ordinary course, it is very inexpensive, something like $45, I believe, to submit it online. But then it takes months and months and months for the Copyright Office to ultimately act on it.
I guess I just meant in like a perfect system, which it isn't, and it's the government. So
right, and we also have the overlay of the way the law works in the United States that you don't have to send your works in to be registered with the Copyright Office for them to be protected under copyright law. You just have to get that registration if you're going to sue about them.
Mm-hmm. And that's a very good point, because I think it's been my experience that most people actually only register their copyright, unless we're talking about some extremely valuable commercial items. But for most digital works, you only register, or you seek to register your copyright after it's been infringed, because you have the copyright protection, as Denise said before. But to be able to sue, you need to register the work. And as everybody's pointed out, that can take 6 or 9 months, and it's just not worth the effort.
Yep. Well, I thought it was an interesting story. I'm glad you guys did too. We'll continue to look into what sort of IP-related blockchain technologies develop. We knew this was coming when we first learned about the blockchain and what it was and what it could do. This is sort of the other shoe dropping to, I'm sure, discussions that we had back then on This Week in Law, saying, hey, you could register your works on the blockchain. Well, now someone's setting up a business to do just that. Also in business for a very long time, and I'm sure near and dear to folks who listen to the show, is the blog/site Boing Boing. We've had Cory Doctorow on the show before. We've had Shenny Jardin on the show and other Twitch shows before. Both of them have been all over our network over the years. And Cory in particular follows a lot of copyright developments for the site. I'm not quite sure if he's written about their dispute. I'm guessing no, because Boing Boing's being sued, and hopefully they're taking their lawyers' good advice and litigating the case as best they can. But they're being sued by Playboy publications because they did a post recently that was just a link and an embedded video to somebody had posted on Imgur all the Playboy centerfolds ever. And Boing Boing thought that was interesting. They are a directory of wonderful things, have been for quite a long time now. And just in the course of the links they collect and pass along each day for people's perusal, that was one of them. And Playboy is taking umbrage at this rather than going after the person who compiled this database of former Playmates. And I guess the video, I haven't watched it yet, but the video, I guess, is a compilation as well. They're going after Boing Boing for posting that link on their site. This is the latest in a long history of people trying to sue over links to infringing material. EFF has jumped in Boing Boing's camp and filed a brief, and hopefully we will get the right determination here that linking to something is not infringement. But Boing Boing is now fighting that battle. Mike, have you taken a look at this?
I have, and I'm somewhat mystified by the claims myself. My understanding of the law when it came to linking, and this is an issue that came up years ago, and I think was soundly rejected by the courts, including the Ninth Circuit. Linking is not an act of copyright infringement. You know, in order to infringe a copyright, you need to violate one of the 106 rights, and linking, providing access to content simply by linking to it, is not an act of infringement. So. Boing Boing is represented by excellent lawyers at Dury Tangri, Mark Lemley and Joe Gratz. You know, they're both terrific lawyers. I read the motion to dismiss. I totally agree with it. And, this case should be dismissed as far as I can tell.
They've both been on the show as well over the years. Right. Joe, I think, a few times. Any thoughts, Matt?
I think that Mike covered this well.
Okay. Peter, anything to add?
I'm just surprised as to, I'm thinking that there must be something more there just because of who Playboy is represented by, because especially with Mark Limley is extremely well known, mostly in the patent field. But for him to just repeat the same tired old arguments with linking makes me think that there's something else going on here rather than a simple linking case. But again, that's just speculation on my part.
Yeah, we'll definitely keep you posted, let you know what happens with it or if more developments occur. A listener sent this in, and I'm not sure who it was or by what medium. I love to thank people when they send things in, and I'm afraid I dropped the ball on this one. Thank you, whoever sent in the link to the fact that the science fiction writers of America are not happy with the Open Library Project, a part of the Internet Archive. Comically enough, the program in question here launched in 2007, so something like 11 years ago. The Internet Archive started scanning books and offering quote-unquote loans of DRM-protected versions for e-readers. And the thing about those versions is they only last for a little while, and then they go away. But the science fiction writers of America are not happy because it's possible to strip out the DRM protection if you're really determined to do so. So they're not pleased that this program has been going on for something like 11 years, and they've complained about it. They call it, we suspect this is the world's largest ongoing project of unremunerated digital distribution of entire in copyright books. Google fared okay on this front back when it won its Google Books case. And over on Slashdot, the post on this points out that the Internet Archive doesn't even have the commercial interest that Google does in its books that it makes available online. It's a nonprofit purely serving the public. And there's no lawsuit about this as yet. It's a complaint from the Science Fiction Writers of America. Any thoughts on this, Peter?
No, I don't really know enough about it to comment a lot about it, but it's certainly something worth continuing to follow because the unauthorized or use of these kinds of things does have an effect on publishers and on authors. So it's I think authors, especially in a niche area like science fiction, are probably very concerned about their unauthorized use of their works, or the use of their works that may impact their ability to make money on their works.
Yeah, it's sort of a continuum, I think, between, this kind of thing that the Internet Archive has been doing for a while and business innovations that people like Amazon come up with, where they allow people to loan digital copies of books that they have purchased to their friends. It's not that far down the road from complaining about the Internet Archive to starting to complain about what Amazon is doing as well. So what do you think, Matt?
I would assume that Amazon has worked out that contractually with their buyers, but I'm not sure if that's true either. I think the interesting thing is that when we think back about the Google Books ruling, is its fair use analysis came down to a market failure, and the question is whether a market failure is a one-way street. So back in 2005 or 2010 or whatever it was, we said that you can't get access to these books. Therefore, Google has done this. There's a market failure, and therefore it's fair use for Google to put this up. The question is whether if these booksellers came together and created something that provided the same function, people are able to get it for a reasonable price. If the market failure in its essence is cured, does the fair use go away for Google Books itself, and therefore this online repository? And there's no law on that, or it's not been done. But that is the logical issue with having a fair use ruling on a market failure, because markets fail and then they can be corrected. And that's obviously that's not what they're bringing here, but that's if you're going to rely on that fair use for these big sort of projects, as Google has done, it seems logical that they can be remedied.
Mike, does it make sense to make a complaint to the Internet Archive, but not to every library in the world that also makes DRM protected versions of ebooks available?
Yeah, it's a really good question. I mean, I can see the argument here, relying on Google Books that this isn't Google Books. I mean, what Google Books did, yes, there was massive amounts. I mean, they had copied over 20 million volumes of books. But in that case, Google wasn't providing wholesale copies of the individual works to end users. What they were providing was little excerpts from the book. And as a result, that's really what the Google case was all about. And Judge Laval said, look, this is ultimately a fair use. So it seems fundamentally different to me in that this open library project purports to be providing actual digital copies of the entire work. And even though it's ephemeral and they ultimately disappear after a certain amount of time, it is a full digital copy. And so I could see content owners saying that this is qualitatively different from the Google Books issue that the Authors Guild pursued.
Yeah.
And
I don't know if that's responsive to your question, Denise, but it seemed to me that there's a significant distinction.
And I just wanted to add there that I think it also depends on how many copies that they have of each of the works, because I mean, a library can lend out 1, 2, 3, a print library of how many copies they actually have. But of course, you can make available an unlimited number of copies of digital works with the obvious impact on the copyright owners, the content owners. So I think that is a very important consideration, really, of what exactly they're doing. Are they lending more than one copy at a time? How many copies did they actually purchase, if any at all? So I think it's a very interesting question.
It is, and I think that we've solved the problem in our earlier discussion on the show. They just all have to be put on the blockchain, right? You know how many copies there were, where they were, where they'd been transferred. Sorry, Matt. I also have to point out that the president of the Science Fiction Writers of America has the best name ever. His or her, I'm assuming it's a her, name is Cat, C-A-T, Rambo. Awesome name. Cat Rambo. And speaking of cats and cats in the hat, you have discovered, Mike, that you are not alone in your propensity to wax poetic about, the places you'll go and the lawsuit about it. Tell us what you found.
Actually, this was sent to me by a lawyer in Cincinnati. His name is Jack Greiner. And he sent me a LinkedIn message this morning saying, "Hey, I swear when I wrote this, I hadn't seen your prior posts." And I got a good chuckle out of it. We exchanged some funny messages back and forth. But yes, Mr. Greiner here had put together a Seussian post that was published by, I guess, Cincinnati.com, or a paper in the Cincinnati area, about the Dr. Seuss and Comic Mix dispute. And I thought Jack did a great job with his post, and I commend it to the readers and our listeners. If you're hungry for more Dr. Seussian type rhymes, this is a really good one.
It's extraordinarily clever, and I don't want to read the whole thing. Actually, I do want to read the whole thing on the show, but we have other stories to get to. So I'll just point out that he has a way with rhymes and read you one stanza, and then you can go get the rest from our discussion points at tagpacker.com/user/thisweekinlaw. Find episode 412 there, and you will find the link to this. It's in its entirety. This one stanza says, "Now, truth be told, and this will wow you, our book won't diminish your book's market value." Huh? Guys got a knack.
Yeah,
all right.
It sure does.
Any thoughts, Matt or Peter?
I can't top that.
I think we all just have to bow down. It's pretty amazing.
No doubt.
Definitely go read the whole thing if you are at all entertained by this. Speaking of entertaining, let's move on to some stories in the entertainment realm. I put this story here because I don't think any of us can dispute that Grumpy Cat is a legitimate celebrity, right? Deserves the caption of Hollywood entertainment, etc. If Grumpy Cat showed up on the red carpet, I'm sure many people would be very excited. Well, Grumpy Cat showed up in court, physically showed up in court, has been suing a company. I think we've discussed this case on the show before, because how could we not? Sue a company that makes coffee called Grenade. Grumpy Cat had licensed its image to Grenade to sell a Grumppuccino iced drink. But Grenade decided it was not just only going to sell a Grumppuccino iced drink, but other things, including T-shirts, Grumpy Cat filed for breach of their contract and violation of Grumpy Cat's trademarks. I think PETA would really like this case.
Oh.
Since Grumpy Cat seems to be asserting a whole lot of intellectual property rights here. And Grumpy Cat won a jury trial, won $710,000 plus $1 nominal damages for breach of Grumpy Cat's contract. So I can't tell you how many people sent me this story knowing that we would want to discuss it this week. A great many of you did, and you are so right. Mike, why don't you start us off?
Well, I think you summed up the dispute beautifully there, Denise. Yeah, you beat me to it. I was going to say something about PETA, but, now my joke will kind of fall flat. So, yeah, so it was interesting to me, and I don't know a ton about the case. There were claims that were brought for breach of contract, copyright infringement, trademark infringement. And as I understand the jury verdict, what they ultimately did was award damages for trademark and copyright infringement, and a nominal amount of damages in the amount of $1 for the breach of contract claim. So interesting, fun case. I'm glad that it was brought to our attention, and glad people were interested in it.
Yes. Can you imagine the jury's delight when Grumpy Cat showed up in court? I mean, that's the jury. If you got to do jury duty, that is the one you want to get on. Sure. Peter, what do you think?
I don't know. I'm just glad I wasn't there for the cross-examination of the cat.
Rare. That cat is not sharing poor Grumpy Cat. I'm sure Grumpy Cat is a happy cat. It just has it has dwarfism and an underbite, which makes it look perennially sort of unhappy. Matt, is this cheering you up?
This is
Grumpy
Matt. Yeah, no, I don't have the DNA sequencing that causes that continual down face. It's just the blockchain comments that bring that up. But yeah, I just thought it was interesting. They couldn't challenge the copyright really because they had paid for the copyright and then just extended their use of the copyright beyond what they had paid for. So it seems like just a really bad business decision that they just weren't going to win that. So don't, when you sign a contract, like, do what it says is kind of what we can take away from this.
Right. The other thing we can take away from this, I've been very tongue-in-cheek about, rough kitty tongue-in-cheek about who holds the rights here. Of course, the owners of Grumpy Cat are very savvy, and once Grumpy Cat became the web sensation that it did a few years ago, they did all the proper legal steps so that they could enforce rights on behalf of their famous cat. The cat does not actually own any rights. Its owners and the various entities they have set up on its behalf do. So something to bear in mind should you find yourself the owner of an internet celebrity animal, that you don't need PETA in your camp to argue that the animal actually has the intellectual property rights. As this case demonstrates, you can go ahead and enforce them as the animal's human. Let's see, what else do we have on the entertainment front? We have this really interesting story from Plagiarism Today that I just bring up. Jonathan Bailey, the author of this, has been on the show before too. He resides in New Orleans, I believe, and has been on the show with us quite a few times, and always has an eye for interesting intellectual property matters. And so I commend his entire post to you to get all the details of this. But what the gist of it is that the way that Doctor Who has set up its writing arrangements, instead of the creators of the show having all the copyrights in the show, the individual writers do. As he points out, if the copyright control for most TV shows, including sci-fi shows, is pretty straightforward. Star Trek, for example, is controlled by CBS and Paramount, as we know. Star Wars is controlled by Disney. In Doctor Who's case, though, back in the beginning of the show, he writes, up until roughly the 5th Doctor, the writers often retained copyright in what they created. So it gets a little muddy, and it makes things confusing in disputes about who owns the Doctor. Mike, have you taken a look at this?
I did. Yeah, I thought it was super interesting. I don't know much about Doctor Who. I know it's very popular in the UK and in all points Europe, I guess. But yeah, it's a phenomenon that that we're not all that familiar with here in the U.S. when it comes to ownership rights with respect to certain characters. I mean, of course, that's been litigated, as we've talked about on the show before, in terms of whether you can claim individual copyright protection for certain characters in films. But we don't really typically run into disputes dealing with ownership interests associated with different components of a particular audiovisual work. So it's a rather unique dispute in that respect, and could be really messy if these rights ultimately have to be litigated. So yeah, it's interesting story.
Last week we were talking about Byzantine music licensing laws, as we often do, and how it's difficult to determine who owns what rights to a musical work. And that's what this is reminding me of, is when you don't have one centralized rights holder who has been assigned all the rights that might otherwise accrue to people like the writers, that you can get yourself bogged down in a mess of trying to determine who owns what. And I think that's what we're seeing, or could see. Apparently this dispute is not as big of a deal as was thought when it was first reported in the Mirror in the UK. The problem was the estate of Marvin Heisman, the creator of Brigadier Lethbridge Stewart, took issue with an episode that introduced a new character that turned out to be Lethbridge Stewart's grandfather. Lethbridge Stewart is a character from the series that the estate of Marvin Heisman claims they hold the rights to. So if you're a fan of the Doctor, you may find that your TARDIS is spinning through time trying to decide who owns the rights to the characters and themes in particular shows. Peter, any thoughts on this?
No, I really don't. I'm not familiar with the show, so it's hard to really get too worked up about something like this.
Matt?
I've seen a couple episodes, so I guess I'm the expert. Doctor Who's great, and but it's interesting that it took him 5 seasons to figure out that we should own the copyrights on this. But also this falls under my bucket of like, this is what happens when you have the continual extension of the Copyright Act, and this may not have been an issue if copyright wasn't forever and 70 years. So that's my 2 cents.
Thank you. I'll take it. And in a moment, we're going to talk about a case. I think we might have brought it up on the show once before, but we need to bring it up now that Mike is back with us. The Sleevey Wonder case. We'll get to that in just a second. But before we do, we're going to thank our first sponsor for this episode of This Week in Law, and that is Grammarly. Grammarly's AI-powered products help people communicate more effectively. Now, what you do with Grammarly, and if you're watching the video, you're seeing a demo of it here on the video. You copy and paste any English text into Grammarly's online text editor, or you install Grammarly's free browser extension for Chrome, Safari, or Firefox. And then Grammarly goes to work for you. It's like you've hired an editor. It will correct hundreds of grammar, punctuation, and spelling mistakes, while also catching contextual errors, improving your vocabulary, and suggesting style improvements. Grammarly scans your text for common and complex grammatical mistakes like subject-verb agreement, modifier placement, comma splice, weak adjectives, missing articles. Grammarly's powerful algorithms are developed by the world's leading linguists and language lovers. You can improve your skills with Grammarly's detailed explanations for all your mistakes and weekly progress reports. And you can write confidently and mistake-free in any medium at all, whether you're just wanting to craft a really excellent, put your best foot forward email. If you're a prolific social media user, you may, especially if lots of people, especially in the professional realm, like to post articles, thought pieces to LinkedIn. That would be a great application for Grammarly because let's face it, one set of eyes on something is never enough to catch every little detail, but your reader will catch it. And when they catch the mistake that you made, your stock goes down in their view. So whether you're posting to LinkedIn, Twitter, Facebook, your blog, anywhere else you write on the web, and it of course does not have to be limited to web writing, wherever, if you're applying for a job, if you're applying for college or any other kind of school and you have to submit an essay, I think this would be a great thing to run through and help you in your writing process. Be sure to check out Grammarly's Facebook and Twitter accounts for fun grammar tips and discussions, and the Grammarly blog offers daily tips and insights on how to improve your day-to-day writing to achieve personal and professional goals. Get started and join more than 10 million happy Grammarly Chrome users today. Download Grammarly now for free at Grammarly.com/twit. That's Grammarly.com/twit. Thank you so much, Grammarly, for your support of This Week in Law. And now let's move to that trademark story. Mike, tell us what a sleevey wonder is.
Well, as far as I know, and this is not from personal experience, this is just from me reading various articles about it. But as I understand it, a sleevey wonder is some sort of sleeve device that one can put on your arm for various and sundry reasons. I'm not entirely sure if it's an article of clothing, I guess, is what a sleevey wonder is, right? So you put on, some of them are maybe kind of fancy, some of them are plain, but you can accessorize your wardrobe with a sleevey wonder. Mm-hmm. Who knew? So sleevey wonder is, and there's an interesting, I think, backstory about this particular name that we can talk about in a moment. But the present case deals with sleevey wonder, and it sued the company Spanx, which is, as I understand it, a large manufacturer of various. It's primarily undergarments. Is that right? I don't know for sure, Spanx, but in any event,
I think they used to be referred to as support garments.
Okay. Right.
Let's just say if you're my age and a woman, you are well familiar with what Spanx are.
Got it. Okay. Gotcha. So Spanx was ultimately sued by sleevey wonder because it allegedly copied, according to the lawsuit, various advertising components and infringed on various trademarks, maybe not trademarks, but copyrights owned by sleevey wonder. One of the interesting twists that's alleged in the case is, or in the complaint rather, is that Spanx had ordered some sleevey wonder products from sleevey wonders a few years ago, and folks at sleevey wonder reached out to Spanx about inquiring whether they wanted to license some of sleevey wonder's IP. Spanx said thanks but no thanks, and then came out with this competitive product. So lawsuit was filed, and it should be fun to see how this ultimately plays out. Now, the thing that caught my eye initially about this story is the name sleevey wonder. Of course, I instantly thought of, when I heard sleevey wonder, I thought of Stevie Wonder, right?
Of course, which you're supposed to.
Right, which of course you're supposed to. And so in doing a little bit of digging, Stevie Wonder owns a number of trademark registrations on the name Stevie Wonder. So I was kind of curious as to why this trademark ultimately went through. It actually sailed through, as near as I can tell, the trademark office. There was no opposition initially filed by Stevie Wonder. And even the examiner didn't initially reject the application based on potential confusion with Stevie Wonder. So I don't know. I thought that was kind of interesting, because I think a lot of people would see this and instantly think, oh, this has got to be a Stevie Wonder related product, just because the name is so similar.
Yeah. So I have two thoughts about this. Number one, it's reminding me of the case where I think it was Khloe Kardashian and her business enterprise had purchased a few items from a small fashion designer and then come out with things. I think it was like a spangled mesh top that was very, and some camo related stuff that were very similar to the things purchased. So this seems to be a trend in how people are demonstrating, hey, you bought our stuff and then you copied it. So that's my first thought. And my second thought is perhaps you could solve that problem by putting the garments on the blockchain. Sorry, I had to, Matt. Remember the Encore people reached out to me because they are speaking at a fashion conference. So it is not that untenable. What do you think, Peter?
Denise.
Yeah, no, go ahead, Matt.
So Denise did two things there, right? So we were put on the ABA's list of like top 100 podcasts, of which there was only 25, which is kind of funny. And second of all, they listed us as describing like drones, technology, and talking about Kim Kardashian West. So Denise single-handedly put the two things I least want to be associated with on the show, Kim Kardashian West and blockchain, in the same points. So I just want to point that out.
Arguably even a lesser Kardashian, Khloe, no, I would never try and determine which is the preeminent Kardashian.
Sorry,
Peter, what do you think?
Sorry for that tangent.
I think it's, again, it illustrates of the idea of kind of efficient infringements with often big companies think that they can get away with and try to infringe on other people's, whether it's copyrights, patents, trademarks, whatever, and then it becomes just a cost of doing business. So I kind of applaud that Stevie Wonder is taken such a strong stand against infringement of this kind.
All right. Well, we're going to have to cobble together our first MCLE passphrase of the show from this discussion. I think we'll use such wonderful sleeves. And what these things are that we put into the show is, if you are a lawyer or other professional and you listen to our show, watch our show, and then apply for credit, continuing education credit in your field, you may need to demonstrate that you watched or listened to the show. And so we put these phrases in to help you do that. If you're a lawyer, you can head on over to wiki.twit.tv, find our This Week in Law page there, and there will be more information for you about how you might go about applying to receive credit for watching or listening to the show in your jurisdiction. We'll put another one of these in the show before it is over to help you out in that regard. And with that, let's move on to talk about some crime and justice related stories. So, Peter, we're getting into squarely into your wheelhouse here, and your book, Intellectual Property and Computer Crimes, which we should mention was originally published, was it 2003?
I believe that's correct. Yeah, I'm just working on the 29th supplement for it.
Right. And so what happens for great legal compendia like this is that diligent folks, authors such as Peter, don't just put out a book in 2003 and expect it to remain current 14 years down the road. No, they continually update them and let you know what is no longer good law, what recent developments have happened that have changed everything. So thank you for all your hard work on that and keeping people up to date. And one of the things that has really evolved over the years since you originally published your book is the Computer Fraud and Abuse Act and how it is being applied and interpreted by courts. We have a new decision from the Ninth Circuit, the Federal Appeals Court here in the Western United States, called Oracle versus Rimini. Can you tell us how that moves the ball down the field at all?
Well, that case involved Oracle sued a company called Rimini, which basically was providing support services for Oracle software as a third-party vendor to Oracle's users to make sure that their software didn't have bugs and was fit for its purpose. And it turned on whether Rimini was allowed to make or actually use. Oracle claimed that Rimini was downloading copies electronically of Oracle software in violation of contracts between Oracle and the third-party vendors. And Oracle sued Rimini under actually state law, under both Nevada and California state law, that in computer crime law that is very close to the Computer Fraud and Abuse Act. And that area has been a hotbed of what it means to actually access a website, access a computer without authorization or in excess of authorization. And in this case, although the language of the statutes, the state statutes, are a little bit different than the federal statute, the court held that even though Rimini may have violated the terms of use by downloading the copyrighted materials electronically, is rather than more manually, it did not violate the expressly did not violate the particular state statutes, and by extension probably would not have violated the Computer Fraud and Abuse Act. But this particular area of law, the Computer Fraud and Abuse Act, especially what it means to download material without authorization or in excess of authorization, is an extremely complicated area of the law, and the Supreme Court, for some reasons that I don't understand, has already turned down 2 requests to hear cases to try to further make this area of the law a little more understandable to the general public. And there's clear split in the law among some of the federal circuits as what it means to download a copy without authorization or in excess of authorization. So I think the whole area of the law is a mess until either Congress comes in and amends the Computer Fraud and Abuse Act, which was originally enacted back in '84 and has been amended a number of times since then, but with really no major amendments since about 2003. So we're kind of dealing with a Computer Fraud Act that was kind of the Model T area of the website, and now we're all driving Lamborghinis or Teslas or something like that. But it's clearly no longer really a relevant, I shouldn't say relevant, but it's really not a law that it's tailored to the 21st century needs of the internet.
So can we rest easier in the wake of this case that if you have violated a website's terms of service, which was what was at stake here, Oracle argued that in its terms of service, it stated that people were prohibited from using automated methods to download support materials from its website. And this is what Rimini was doing. So Oracle attempted to go after them under these equivalents of the Computer Fraud and Abuse Act, and the court shut that down. So have we come far enough away, I guess is what I'm asking, from the Lori Drew case, the mother who a long time ago now created a false Facebook account and used it to bully a woman, a young girl actually named Megan Meyer, and to the point where she actually committed suicide. So the terrible facts of that case and the fact that people were so upset with what had happened to the poor young woman who died, I think contributed to the fact that federal prosecutors went after Lori Drew for violating Facebook's terms of service in creating this account, and convicted. Well, the Lori Drew case, I can't remember. She was actually convicted or no?
She was convicted. And the judge actually threw out the conviction.
Threw it out. But yes, that's why I'm confused.
Yeah, she was convicted of a misdemeanor, but yeah, she was. The jury did convict her, and the judge, in his infinite wisdom, did throw out the conviction.
Right. So are we more secure that sort of thing won't happen again based on these trends that we're seeing with courts applying the law?
Well, I think since I'm trying to be a good lawyer, the answer to your question is it depends. And what I mean by that is you in California and in Washington State can probably, and people who live there and perhaps commit these sorts of things or engage in these sorts of activities probably can rest assured that they will not be prosecuted by the federal government for accessing a website in violation of the terms of service of the website. I think the Ninth Circuit has spoken pretty clearly on that issue. But unfortunately, as I mentioned earlier, there are other circuits, in particular, I believe the Fifth Circuit, and now I can't off the 11th Circuit, I believe, but there are certainly other circuits in which the answer is not quite as clear. So we certainly have a disagreement among federal circuits, among major federal circuits, as to what this means. So maybe you could sleep better tonight in California, but maybe not so well in Florida.
That's an excellent point. Mike, what do you think?
Yeah, I don't think I have anything further to add. I mean, I think Peter's point is a really good one. That seems like this issue is ripe for the U.S. Supreme Court to step in and clarify, giving all the disparate outcomes in the various federal circuits. So we'll see what happens.
Peter, Virgil in IRC is bringing up Aaron Swartz, obviously, and his copying material from JSTOR and his long tragic experience with the Computer Fraud and Abuse Act, and is asking if this Rimini decision or any of the similar decisions out of the Ninth Circuit would impact that. My gut is no, because but you weigh in. You're more versed in this than I am.
I mean, again, that brings up what I was just saying, that the Swartz case was a case out of the District of Massachusetts. So the law in the District of Massachusetts is not as evolved or is more ambiguous than it is in California. So I think there's nothing that would prevent the federal government, from the U.S. Attorney's Office in the district in Boston or the District of Massachusetts, for example, from bringing a case, again, similar to the Swartz case.
Yep. Matt, any thoughts?
Nope. I'm in the Seventh Circuit, and I know that they don't have good law on it, so I sleep not as well as you guys in California and Seattle.
We're sorry. Are you sleepless in Seattle about this, Mike?
Yeah.
No, I'm going to sleep just fine tonight.
Yes, good. Really interesting story, Peter, that you pointed out and suggested for our discussion today. Involves a Chinese national. The most fascinating thing about this, I'll let you talk about it in more detail, to me, is the fact he's been convicted of under the Economic Espionage Act for stealing trade secrets from IBM. But none of the actions related to this case, other than the fact that IBM is a U.S. company, took place in the United States. The guy was employed by IBM in China, right?
Correct.
And all of his actions took place there. Tell us what happened.
Yeah, I mean, this is again, I think it's a very interesting case. It's the area that I've been doing a lot of work in recently, and there are a couple things that really jumped out at me about this case. As you said, Denise, he was a Chinese engineer who had limited contact with IBM in the United States. And despite that, apparently he had gained access to some proprietary computer software from IBM. And it's not entirely clear whether he sold it to a Chinese company or he set up his own company in China to make use of it. And he was brought back to the United States, or he came back voluntarily to the United States, and he was arrested and ended up pleading guilty. And I think there to me, as I said, at least three things that are very interesting about that. The first thing is that he was sentenced to 5 years in prison, and I think that a lot of people would be surprised as to now how long some of the sentences are for theft of trade secrets. 5 years is now not a typical sentence that somebody may be sentenced to for theft of trade secrets. The sentences are based primarily on the value of the trade secret stolen, and since trade secrets now are arguably can be worth tens of millions, if not hundreds of millions of dollars, under the sentencing guidelines, that can end up to a very long sentence indeed. And there have been even longer sentences than the 5 years here. And we've seen a real progression of sentencing. When I started with the Justice Department, we were lucky to get sentences in anything other than a suspended sentence or 6 months home confinement, and now we're seeing some really very long, lengthy sentences. And the other thing that you mentioned, Denise, which is a really good point, is his contacts with the United States were very limited. He was a Chinese national. Apparently, most of the activities that he did engage in took place in China. The sale of the infringing or the stolen software was apparently in China. But under the Economic Espionage Act, as long as there's one act committed in furtherance of the theft, that will give U.S. courts jurisdiction over the activities. We can assume that there was some connection in that regard with the United States, because he was a Chinese national and was not a Chinese. It was a Chinese national, not a U.S. citizen. And then the third point that really jumped out at me about this is the continued pattern of the government of bringing these kind of cases in a very large number against individuals who have some connection with China, whether they're Chinese nationals, whether they're working for a Chinese company. And I did a study a few years ago on this, and it's somewhere now between 35 and 40% of the cases that the government is bringing under the Economic Espionage Act for theft of trade secrets involve this connection with China. So it's just a continuation of the pattern of the United States really going after these kind of cases, taking them very seriously, and there is the real grave risk for a defendant in this case that they're going to be spending a substantial portion of time in federal penitentiary.
Yeah, I wonder if the act that triggered jurisdiction of this U.S. court and the sentencing, and presumably he'll be extradited and do prison time here in the United States, was simply his employment for a U.S. company. Do you think that was it?
That could have been it, and he doesn't actually, Denise, I don't believe from reading it that he has to be extradited. I think he actually came back to the United States and was arrested coming back to the United States, and in fact pleaded guilty here in the United States. So I think he's basically they're fitting his prison uniform on, probably even as we speak. Right.
So if he had stayed in China, maybe he never would have been prosecuted. Maybe they wouldn't have gone to the trouble of extraditing him. What do you think about that?
There have been, I think, to the best of my understanding, there has been not a single successful extradition from any country under the Economic Espionage Act. There was a case early on in the late 90s that the United States sought to extradite a scientist from Japan who had allegedly stolen trade secrets from the Cleveland Institute, the medical school there, and he was a researcher there. And after lengthy hearings in Japan refused to extradite him on the basis that the crime that he was accused of committing in the United States was not a crime in Japan. So it was the first time ever that the Japanese refused to extradite somebody to the United States to face prosecution. And I believe that's actually the only time the United States has even tried to extradite a foreign national. And in that one time, it was unsuccessful.
Mm-hmm. Mike, any thoughts?
Yeah, when I read about this case, it reminded me of a case we've talked about previously involving Kim.com. Different set of facts, of course, but the parallel, or what they have in common here, is kind of the long arm of U.S. laws when it comes to violation of IP rights abroad. Of course, Kim.com had a bunch of assets seized that I think were all in foreign countries. He had never been to the U.S. and ultimately was unsuccessful in having the Supreme Court hear his case, as I understand it. I know Peter is probably much more familiar with it than I am, but in that case, he had never been to the U.S. And the U.S. was still able to seize assets under the civil forfeiture statute. Nonetheless, it seemed to me like, wow. We're seeing the U.S. be pretty aggressive in application of its laws when it comes to IP violations abroad.
Yeah, in that case, I believe he's still in New Zealand fighting extradition. I think that's where things stand in that case. But as he said, that they were able to seize a substantial portion of his assets prior to that. But he's still in New Zealand himself, so he's free.
Matt, you're closer to what law professors are saying these days about jurisdiction and what triggers it. I'm wondering what your reaction to all this is.
Oh, I try not to speak for law professors as much as I can. I'm not an expert in jurisdiction in any way, shape, or form. I did have a question for Peter, though. Is the terms of the prison sentences coming down under just the Criminal Trade Secret Act? Are those similar to the ones that are brought for trade secret violations of the Economic Espionage Act, or are we seeing a difference in between the national and international violations?
Well, that's a good question. The Economic Espionage Act, really, there are two different aspects of it. There's the straight Economic Espionage Act, 18 U.S.C. 1831, and that when people think about economic espionage, that's what they're talking about. Somebody a foreigner basically steals trade secrets from a U.S. company. That's the first part of it, and the second part is simply a theft of trade secret act committed in the United States by an individual, by a company against some third party. Under the sentencing guidelines, the penalties are somewhat more severe for economic espionage. It's a somewhat higher baseline sentence than under theft of trade secrets. But once you start, as I said earlier, once you start getting up in terms of the dollar value of the trade secrets that actually taken, it gets to be pretty similar, and there's not a great deal of discrepancy. In corporations who are involved in theft of trade secrets, I believe can face fines now of up to $15 million, or 3 times the value of the trade secret. So again, it does provide for substantial penalties for both theft of trade secrets and economic espionage.
Okay, well, speaking of the long arm of U.S. law, this was a really interesting story having to do with an art exhibit at John Jay College in New York. And it's the John Jay College of Criminal Justice. And you know how sometimes, just sort of anecdotally, maybe this is purely the work of Hollywood movies about the criminal justice system in the U.S. But if you've watched some of those movies and portrayals, maybe you've come away with the impression that when people spend time detained and have lots of time on their hands, they're trying to develop themselves or keep their minds occupied in one way or another, and perhaps they're getting creative while they're engaged in their detention, whether it's works of visual art or writing or poetry, what have you. Certainly, that's one thing that it seems to happen when people are detained, at least for some people. So there were several artists who happened to, or detainees at Guantanamo Bay Naval Base in Cuba, who either were artists before or became artists while they were detained. And the John Jay College of Criminal Justice was hosting an exhibit of their art. 8 current and former detainees from Guantanamo. It was called Ode to the Sea, Art from Guantanamo. It went on display last fall. And that's when the U.S. government got involved. And none of us, we were talking before the show, actually know the answer, or maybe Peter does. Maybe we were talking about it before you got on, Peter, here. But what the Defense Department is arguing here and halting the export of the artwork and shutting down the exhibit is that the works made by the prisoners are the property of the United States government, and that they're not authorized to be displayed. What do you think about this, Peter?
My guess is that that's maybe the correct understanding, because obviously you give up and forfeit many of your rights when you go to prison, and the government has a great deal of say as to what you can do with your with your time. And I think there may be a distinction that needs to be addressed here between allowing people who are in very harsh environments perhaps to be able to engage in painting and do something like that for a variety of reasons. But I think that doesn't mean that the government wants to permit, and I think arguably nor necessarily should it permit, those works to be on public display. So I think the United States probably has a great deal of say into whether or not those works can be publicly displayed.
Right. And you obviously do forfeit a bunch of rights. It seems like you may, without knowing it, be granting the government a license to your creative works. What do you think, Mike?
Mm-hmm. Oh, yeah, this is a really interesting story. So as a matter of pure copyright, I think that the prisoners have a better argument here. Now, there may be some other statutory or regulatory authority that when you're in a federal penitentiary or federal prison, you forfeit any of your copyrights. But under the copyright statute, the government owns a work that's created by a federal employee or federal officer acting in the course and scope of his or her employment for the federal government. So it's hard to imagine that these prisoners fall within the definition of a federal employee or federal officer. Even if they do, I'm not sure that they were creating these works in the course and scope of their quote unquote employment for the federal government. So that seems to be maybe a bridge too far from a copyright standpoint. I also would note that the Copyright Office publishes what's called the U.S. Copyright Compendium, which is essentially the Copyright Office's own interpretation of its agency duties and how it should go about carrying out various acts such as registration and how it deals with applications. The compendium doesn't have the force of law, but there actually is a provision in the compendium that says we will accept applications for copyright by prisoners. So at least according to the compendium, the Copyright Office appears to take the position that prisoners, when they create works when they're in the clink, they still have copyright protection and own the copyright there. But very fascinating legal issue here.
Can I just one more thing that I'd like to throw out there is that the people who are creating these works, unless my understanding is incorrect, they're not even federal prisoners. They've been determined to be enemy combatants, and I don't know if that has any impact on their rights. So they're not really, they have different rights than a normal prisoner in the federal system. They haven't been found guilty and simply being held as an enemy combatant. I don't know what that means, but it's just one more wrinkle in this story.
Yeah, the piece that we have on this in our discussion points out that only one of them has actually been charged with a crime. So they're in that strange world of being a Guantanamo uncharged detainee. What were you going to say, Matt?
I was going to say what Peter. Oh, sorry. Go ahead, Mike.
Go ahead, Matt. No, go ahead.
No. I was going to say what Peter said, and that just complicates it. I mean, we treated them as enemy combatants to allow them to waterboard and do such things that clearly would have violated their due process rights if they were citizens, or if they were just in prison here. The interesting thing is if the piece of property is already in the hands of someone else, so it's already at the museum, from what I understand. It's not like the United States just held property over this the whole time, right? So someone, I'm assuming, like left the prison with this, and it's just a question of like, did they give it to them, and then are they just trying to say that you can't like put this on public display? I think it's a much harder argument if they're saying you just can't put this on public display, rather than saying the property was never yours to begin with. Because I do think that they're going to have a due process problem if someone has the property within the country and they're just saying you can't publicize it because it's not your property. That seems a much more complicated argument.
Right. So the article says, obviously we don't know all the details and we're trying to suss it out from the language of this piece, but the artworks were by 8 current and former detainees at Guantanamo. So some of them are no longer there, and maybe they brought the works out with them.
Yeah, I mean, I'm certainly no expert in this, but it seems like if the government's going to let them leave with something, that at least gives the presumption to the individual that that's their property. But enemy combatants, and it's very complicated. But naturally, it seems like it would be your property. If you leave with your shirt, you don't expect to have restrictions on that, 10 years down the line.
Later in the piece, it says some detainees have told their lawyers that guards informed them their art might be burned if they are released, or that excess art in their possession would be confiscated. Strange. Mike, you were going to chime in?
Yeah, I was actually going to mention something that I think makes this even a bit more complicated than I initially thought of, which is I was looking at this purely from a copyright standpoint as to whether the Copyright Act applies. And it seems like the prisoners would have a pretty good argument that they're not federal employees or officers. But now that I think about it, I'm not even sure that the copyright statute applies because, as Peter had pointed out, these guys are being held as enemy combatants. They're not U.S. citizens, and they created these works. Guantanamo's in Cuba, right? So they didn't even create it here in the U.S. So I'm not sure that our statute even applies, which makes this even more of a conundrum as to what law is at issue here. So
fascinating.
So I guess I've done a complete 180.
That's what we're here for, Mike, to make you make everyone's head spin, make you rethink everything you hold true and valuable. All right, with that, I think we'll thank our second sponsor for this episode of This Week in Law, which is Grasshopper. If you're not familiar with it, Grasshopper is a virtual phone system designed for entrepreneurs and businesses. Grasshopper works just like a traditional phone system, but requires no hardware purchase. With their iOS and Android app, callers can reach you wherever you are on your mobile phone. Grasshopper allows you to keep your existing number so you can maintain your brand. When you make your call, your client will see your Grasshopper caller ID instead of your personal phone number. So if you are in business for yourself or you're operating a small business and really want to have a professional presence, this is a great way to go. You simply select a toll-free or local number, record a custom greeting, and add multiple extensions for your business. Toll-free numbers are great for marketing and make your business sound more professional, of course. Set up department and employee extensions with custom call forwarding to any phone in the world. Get voicemails emailed to you as audio attachments. You can also send and receive SMS text messages from your business number. So even if you're not a huge business, all of these features are exactly what you would want out of a very expensive, very sophisticated phone system for a large business. What you can do is join the over 250,000 Grasshopper customers today. Plans start at, get this, just $12 a month. You have a 30-day money-back guarantee. You want to turn your smartphone into a business line, people, with Grasshopper. You're going to save $50 on your order, too. $12 a month is already a bargain, right? But $50 off of that, you're going to go to trygrasshopper.com/twit, and that's what you will find, $50 off, even their very reasonable pricing. That's trygrasshopper.com/twit. Thank you so much, Grasshopper, for your support of This Week in Law. All right, we have some patent issues to get to next. Matt, let's start with you. You've mentioned a couple of times on the show that you were working on something. It's not like you're not busy helping us out here with the show and attending law school full time. What have you been working on, and where does it stand now?
So this is actually something different.
Sorry about that.
No, that's all right. This summer, I worked at the Institute for Justice in D.C., and they had litigated previously over whether stem cells, which are derived from your bone marrow, are organs or not. And they won in the Ninth Circuit, and so they are not organs. The reason that they brought that litigation was whether if you can compensate individuals for transplants of stem cells for organs. These stem cells are used to treat individuals with leukemia and lymphoma and anemia, and so at the Obama administration was preparing to rule that it was still an organ even after the Ninth Circuit said it, because it was a legal technicality. But then the Trump administration came out and declined to rule, and therefore, for at least now, it's legal to compensate individuals for stem cell donations. And so we are building out a marketplace for that. We are doing it just locally, but we have put the website live. It's ParetoLifeSciences.com, and we're going to try to sign up donors and see if we can save a couple lives while we're at it. So
that's really cool.
Yeah, it's been a fun project. It's it's a really interesting study in just like an economic analysis of getting people to sign up. The real issue with donation right now is that we've got 60 million people signed up to donate, but when people call, they only 1 in 10 donate. So the assumption that we're making is that by paying them up to $10,000, we can get them in the door and donate and save the people in need. So that's kind of fun. You could go check it out, and we'd be happy to take your email address. We're not sending out swab kits yet. We're just doing that locally in South Bend. But in a couple months we will, and welcome any feedback anyone has.
You know what I'm going to say.
Wow.
What are you going to say?
I'm going to say, can you put stem cells on the blockchain?
Blockchain.
Oh! We're going to blockchain your DNA typing. And I'm going to get Kim Kardashian as a sponsor.
Hopefully so. You could do worse.
No, I would actually really enjoy it if she did.
Of course. Well, thank you for that update. That's very, very cool. Peter, tell us about the patent killing fields of the Patent Trial and Appeal Board.
Okay. Well, this is a subject matter that I've become very passionate about recently. after representing many small inventors over the past 5 to 7 years. And before getting to that particular patent killing field article, it really, what they're talking about here is really the weakening of patent rights in the United States. And there's been a lot of adverse press, especially in the past 3 to 5 years, about patent trolls and how much money they're costing the U.S. economy, and the hurting innovation. And really, the statistics and the accurate analysis that has gone on really shows that the opposite, in fact, has been true. For example, the U.S. Chamber of Commerce last year, and they came out in their study on patent rights in the United States, what country protects patent rights. And in that particular study, prior to that, under the U.S. Chamber of Commerce, the U.S. had always been one or two. And for the first time in 2017, we dropped all the way from number 1 to number 10, and we're now tied with Hungary, which is not exactly known as the great hotbed of patent protection. And I think so. The story that I just want to touch upon briefly really shows the steps to which patent rights are under threat in the United States. And a lot of it arises out of the creation of the American Invents Act, which was a major piece of one of the biggest pieces of patent legislation in the past probably 50 or more years. That was enacted by Congress and became effective in 2014. And one of the critical pieces of that act was the creation of something called the Patent Trial and Appeal Board, which allows companies to challenge the validity of patents outside normal procedures, gives them companies a much greater rights to challenge these in the patent office. And there's something called the PTAB, and the PTAB can now find that patents are invalid even after they've been upheld numerous times in federal courts and federal litigation. So what the article discusses, and it's an article that comes out of something called IP Watchdog, written or edited by a guy, Gene Quinn, who's really one of the leading patent people in the United States. And they've put together some real interesting statistics here. And I just want to kind of quote a little bit they say here that there have been 168 cases where the PTAB has overruled the final determination of a constitutional judicial office. So it really shows that the PTAB is a much more anti-patent friendly forum than Article 3 and courts, and it has had a real effect on the ability to enforce patents in the United States, especially among single inventors and small companies who simply do not have the money to be able to defend their patents in the PTAB against actions brought by large companies, especially since the odds of winning a case in front of the PTAB is not all that great. And as we were discussing before the show, there's an interesting case that was argued a number of weeks ago in front of the Supreme Court that challenges the constitutionality of whether the PTAB can basically deprive an individual or a company of their property rights once they've in fact been granted by the patent office, and whether they have the authority to take away those rights. So this is an area of the law that I think is really having profound implications for the continued technological competitiveness of the United States. And it's also an area that hopefully the Supreme Court, though it's unlikely, may step in and create and uphold some patent rights. One of the few, I think, bright spots in this area of law, if I may offer, is one of the real anti-patent proponents in Congress. The Californians may know of Darrell Issa, and he has been, even though he made a lot of money from selling a company that was very patent savvy, has been really at the forefront of curtailing patent rights. So for people like me who are very involved in this area, we're not sad to see him resign from not run for re-election again. So that's my 2 cents of political commentary here as well.
Yeah, those of us in California might pile on various echoing enthusiasm for Darrell Issa stepping down for various reasons. So it seems to me like what's gone on here from your description, Peter, is that the PTAB was established because of dissatisfaction with the volume of patents and the quality of patents that were being granted. But you and Gene Quinn and Steve Brockman, who've authored this piece that we're discussing, feel that it's gone overboard in the other direction. Am I getting that right?
Yeah, the whole idea was that in the last beginning probably 10 or 15 years ago, there was a great deal, as you point out, of perhaps correct criticism that the patent office was granting many patents that probably should not have been granted, and the mainstream press was able to seize upon some of these inventions, and I can't think of one right off the top of my head, but kinds of things that really should not have been granted. And basically, the Congress took the approach of, so let's throw out the baby with the bathwater, and really went wholeheartedly in the other direction in an attempt to really correct some of these defects in the patent system. And now we're in a system where clearly there are valid patents that are worth a great deal of money to the inventors, to the companies that have relied on them, that are being found to be invalid for some reason by the Patent and Trial and Appeal Board, even after they've been able to enforce the patents, and even after those patents have been found to be valid by an Article III judge in a district court.
Well, that's not good. Matt, you have some thoughts on this?
Yeah, I'm interested to hear a little bit more from Peter, but I wasn't aware that they were actually overturning Article III judges' rulings before this. So I think it's really interesting, and that's probably a better argument
Let me just correct that. They're not overturning their explicit ruling. What they're doing is they're fine after perhaps an Article III judge has found the patent to be invalid. The PTAB is then saying that those patents that were held to be invalid are invalid, so depriving a company or an individual patent owner from being able to use that patent in ongoing efforts to enforce it. It doesn't necessarily affect the decision that an Article III judge has been made in that particular case, but it does affect the overall validity of the patent.
Yeah, and but it at least overrules a part of the decision, which is if part of the decision is this is valid or invalid, and then they're able to go and review that as an administrative court. That's really interesting. Yeah, I think that from I'd be interested to hear, Peter, what is your analysis of the oil states case, is the one we're talking about, for the constitutionality of the PTAB in general. As he pointed out, the basis of it is that patents are private rights. They're granted. Once they're granted, the government can't take them away through an article without Article III. Without an Article III court. I'm interested to hear what your take on that.
From what I did not have time to attend I would have liked to attend the Supreme Court argument back last fall. But what I read on it, I think that it seems unlikely that the court is going to buy that argument and probably will uphold the constitutionality of the PTAB. That's my sense. I hope I'm wrong, but that's what seemed to have been the widely circulated opinion of people who attended that oral argument that day.
Interesting. Yeah. I think that this just has really interesting ramifications to follow. and we had talked about the copyright case of whether there could be a small claims copyright case, and this this deals with that too, of whether an Article 3 court can take away those rights or adjudicate on those rights as well. So it's just a really interesting area to follow, and we'll see what comes about.
Mike, any thoughts before we move on?
Yeah, I mean, I think there's also potential implications here in the trademark context as well, because if the court's going to say that the PTAB process is unconstitutional because an Article 3 court needs to adjudicate these rights, I think the same rationale would arguably apply in the context of trademark opposition or cancellation proceedings. For example, once a trademark is issued by the Patent and Trademark Office, that can be challenged. You could challenge it in federal court. Somebody could challenge your rights to that registration in a federal court, but you can also do it before the agency itself. So it seems to me that if the court says that in the Oil States case that it's unconstitutional, maybe that same rationale applies in the context of trademark cancellation proceedings too. I don't know, but it raises an intriguing possibility from my perspective. I don't know, Peter, Mike, and Matt, if you have any thoughts on that.
Does after the trademark review, does that go to the district court, or does that go to the Court of Appeals to review that decision?
From an opposition or a cancellation proceeding?
Yeah, sorry. Yes.
There's actually a choice.
I think that's right. You could seek de novo review before the district court, or you can appeal it. Is to the federal to the federal circuit.
That's correct. Okay. You actually have a choice. The one thing that I would I don't know how relevant it is, but just off the top of my head is the fact that patent rights and trademark rights come from different clauses in the Constitution. Patent rights is something that is recognized as original grant in the Constitution. Along with copyrights, whereas trademarks, as we know, basically became a right that was enshrined under the Commerce Clause, and hence the need to prove the interstate component of a trademark right. And I'm not sure if that would give trademarks any lesser sort of property right, but it's just something that occurred to me.
All right, let's see. Let's put our second MCLE passphrase into the show. Let's make it babies and bathwater in honor of our current discussion. And let's also take a moment to mention, as we did last week, that if you haven't taken the twit.tv audience survey yet, you should. It's at twit.tv/survey. My co-hosts, have you taken the survey yet?
I have not, but I will.
Yes. I encourage you to take it too, Peter.
I will.
All right, guys.
I will definitely do that.
Enlist all three of you, and everyone listening and watching, please go take the Twit survey. We do this once a year. We ask you about the shows that you watch on our network and various other things. And it's very helpful to us to know what's working and what's not at the network. So please give us a hand and take the audience survey. With that, I'm going to go to our concluding material for the show. And we're going to do the tip of the week first. And the tip this week is that if you are Burger King, you can very effectively explain the entire net neutrality mess with the Whopper. Victor, I'd love for you to play the entire ad here for us.
There was. With net neutrality, some people, for what it's worth, just,
I don't know exactly what it is.
Got a number one. Hey, how you doing?
Do you know what number 98, what's going on with it?
Number 98, you got the Whopper?
Yeah.
So you got the slow access Whopper pass?
Wait, what?
It's on the menu right there with the fast, medium, and slow.
Slow MBPS, fast MBPS, or hyper fast MBPS. MBPS, of course, standing for making burgers per second.
So if we want a Whopper now, we have to pay $26.
Well, that's how you get it fast. That's the highest priority.
This is like a lane system?
It's gonna be like 15, yeah, fast lane, slow lane. So like maybe like 15, 20 minutes.
What are you talking about?
She's my favorite right there.
Sell more and make more money selling like chicken sandwiches and chicken fries, so now they're slowing down the access to the Whopper.
Were you given an option of chicken sandwich or?
Yeah, I don't want a chicken sandwich, Robert. I want a Whopper.
Do you have any Whoppers ready that aren't?
Yeah.
What I was a little mystified about is whether these were actors or real people.
What? You can't give me the sandwich? It's ready, but you can't give it to me?
The Whopper neutrality was repealed. They voted on it.
Oh my God, this is the worst thing I've ever heard of.
See, like he got the fast, and now he's getting his.
I come down on them being on the side of them being real people.
Now he's a higher priority, so.
Either that or they're good actors.
Guys, like, I love
Yeah.
They are.
If you'd like,
This is a bad dream right now. I just want a burger, brother. A burger.
I feel like I'm going to say this is crazy.
Here's what I'll do. You have the bag, and I can put it in the bag in 42 seconds. Hold on, 10 seconds.
We don't make the rules.
You just enforce these ridiculous rules?
Fortunately, we have to.
Guys, come on.
I felt like I was being taken advantage of in a sense. Just as a customer coming in to get their food, it felt like a power move.
They already changed the policies overnight or whatever.
I didn't think that ordering a Whopper would really open my eyes up to net neutrality.
The Whopper actually taught me about net neutrality. It's stupid, but true.
Slow clap.
Yeah.
Bravo.
Just brilliant.
Burger
So
King. So good. And there's a wonderful piece at Motherboard by Kaylee Rogers who points out that bit at the end where the Burger King is drinking from the big Reese's mug is actually trolling Ajit Pai because there's a photo of him drinking from an enormous Reese's mug.
That's funny.
Hilarious.
Just so well done. And the other thing that Kaylee says that's so funny is, my job is to explain complex technical and policy concepts. And I think I'm pretty good at it. But a new Burger King ad explaining net neutrality put me to shame. Yes, really. So good job, Burger King, on helping us and many people who probably haven't even thought about it understand net neutrality and what's at stake there. It's a very concrete way to lay things out. It reminds me too of toll lanes on roads being a good analogy. But what could be a better analogy than the Whopper that you must have and don't want to pay $26 for. So if your friends are coming to you asking for an easy way to get their heads around net neutrality, now you have one. Thank you, Burger King. Our resource of the week is Data Privacy Day, which is coming up this Sunday. This is a day of awareness put on by Stay Safe Online and the National Cybersecurity Alliance. You can get involved in a host of different ways. You can, just take the opportunity of the day to think about various things that you're doing, your business might be doing, that can acknowledge and take responsible steps about data privacy. You can attend a data privacy event. It's basically a way of bringing awareness to an important issue, and it is this Sunday. So head on over to staysafeonline.org. They have a whole page dedicated to Data Privacy Day this Sunday, and how you can help raise awareness about the importance of respecting privacy, safeguarding data, and enabling trust. And finally, of course, we have our animal selfie of the week. We're sticking with our bird theme of animal selfies. Last show, I believe we had a bird as well. We've had seagulls on before, but this is a good seagull for you. I love that the idea was just to feed the seagulls, apparently, out on the sunny deck. And then, of course, this happens. The seagull cinematographer is born. I love the fisheye effect that you get from a seagull-born GoPro.
Yeah. Oh, the speed tracker in the corner is pretty cool too.
Yeah.
Oh, yeah.
We have metadata about the seagull flight.
Yeah. Oh, hello.
Yep.
Oh, yep. They're not food.
That's great.
It decided that was just too heavy to carry around. So thank you, Seagull, for the lovely view and your wonderful talent with the camera. Any thoughts about our animal selfie of the week this week, Mike?
Boy, I think that says it all. Nothing further.
Peck, peck, peck. Matt?
I just really hope PETA watches our show. That would just make me so happy.
I know. Well, we certainly acknowledge their role in the realm of intellectual property law and its development or otherwise. Every week, in fact, we do. So with that, we'll go ahead and conclude this episode of This Week in Law. It's been a very fun one. I am still in an exceptionally good mood. Thank you very much, gentlemen, for helping keep me that way and for joining us on this episode today. Peter, it's great to see you again. Oop, you might be muted. All right, we'll say goodbye to Peter in a moment. In the meantime, I'll tell you everything that you should know about if this is the first time you've tuned into This Week in Law, how you can continue to join us week after week. And that is you can join us live is one thing that's fun to do. We record the show every Friday at 11 o'clock Pacific time, 1800 UTC. And if you go to twit.tv and click on the Watch Live button, if you're using a computer to access the show, then that's how you would join us live at that time. If that doesn't work in your schedule, if you'd rather kick back on your couch, watch on your TV, or watch on your phone while you're working out, or just listen to the show, there are a myriad of ways that you can join us and enjoy the show at your leisure, on your device of choice, in your venue of choice. You go to twit.tv/TWiL, you will find all of those ways detailed for you. So it doesn't have to be a live experience, but it's fun if you can join us when we record live. That's when you can jump into IRC with us at irc.twit.tv, play along with us while we do the show. If you'd like to get in touch with us between the show, as lots and lots of people do, and we're so grateful that they do, Twitter is a great way to do that. I'm D Howell on Twitter. Mike is J. Michael Keys there. And Matt is Law Pint there. So, just send us an @ on Twitter. Let us know what has come through your feed that you think that we should see. We greatly appreciate that. Or you can email us as well. I'm Denise at twit.tv. Mike is Mike at twit.tv. And Matt is Matt C at twit.tv. Let us know what you've seen that you think we should pay attention to. What else should you let us know? Let us know what you thought about the discussion that we had, any further thoughts that you had, any points that we missed, anything you just want to add. Please go ahead and get in touch with us. Let us know what's on your mind. You can also find us on Facebook. This Week in Law has a page there. We use that page to put up links throughout the week that we're thinking about discussing on the show. You can also reach out to us there, again, with things that have come through your Facebook feed that you just want to share to our page and let us know that you thought that it would be relevant for us to take a look at. We have a Flipboard magazine, too, that you can get more actively involved in if you'd like, or you can just check it out and see, again, what we're following along with during the week, talking about on the show. That I'm D. Howell on Flipboard, and the magazine is logically enough called This Week in Law. And if you do want to get more actively involved in that, just shoot me an email, and I'll add you as an editor to that magazine. You can add links to it directly. I think Peter might be back audio-wise. Peter, are you with us? Maybe?
He's here, but
no audio. Peter, well, you can hear us. So thank you so much for joining us. It's been a great discussion. We really, really appreciate your time and your insights, and we'll have you back on again soon. Thanks so much.
Isn't Mike a lip reader? He can do this for us, right?
Mike, perhaps you could recite verse for Peter to sing us out with.
I don't know if I can do that on the spot. But it was so great to be with all of you again today. And Peter, thank you so much for your insight and being with us. That was a lot of fun. Very enlightening show today.
Yes.
Yeah, your wealth of knowledge. Thanks. Your wealth of knowledge is exceptional. This is the second time I've been on with you, and you'll always take away a lot. So thanks.
And thank you, Matt and Mike, for joining me per usual. It's been a really fun show, and I'm looking forward to seeing you guys and hopefully all of you watching and listening next week on This Week in Law. Until then, take care.